Good morning, Mr. Gesson. This is your 9 a.m. wake-up call. You have a webinar to do.
Holy smokes! Is it this morning we're doing the webinar? Wow! Look at all these people here. All right. Well, let's do it. Good morning. It is Saturday, August 6th. It's a beautiful morning, and I'm very honored to have so many physicians, clients, and CPAs on the line today listening to this. Now, going to page 2 of our, trying to go to page 2 here. Hold on, we're just, there you go. Go into page 2 if you want to get fancy. This is the instructions on what you hit if you want to speak and ask a question, or if you'd like to raise your hand and send us a question. So Janine is here. She's going to help me manage that, but we'll try to take questions at the end. And our presentation today is on cornflakes and estate planning mistakes, but I wanted to point out for you some other ones that we're doing here. And by the way, all of these get downloaded to our website, so you can watch them at your convenience, and feel free to forward them to other people. We're going to talk about the new Florida Power of Attorney Act on Thursday, August 18 at 5 p.m. That's going to impact a lot of powers of attorney that are done in the future. On August 25th, with Chuck Wasson of Wasson Insurance, we're going to present what Mary Poppins didn't know about umbrellas. Ensure that your insurances will insure you. And that's going to be a 15-minute presentation. Then on Thursday, August 25th at 5:30 p.m., what to do if both spouses are doctors. There's some super challenges and some good opportunities where you have clients where both spouses are doctors. Monday, August 29th, we're giving a B&A national webinar. That one you would have to pay to attend, and that is that dentists are different. It's tax planning for dentists and how the rules uniquely apply to them. Tuesday, August 23rd, we're giving a presentation called Riders on the Storm, how to make sure your insurances don't have catastrophic gaps. So if there's anything else you'd like to see us present, please let me know, and I'm going to go into our presentation now. I have a checklist on page 4 which talks about the most common errors that we see in the estate planning area. And I'm just going to go over these with you now. You can see the cursor here. Number 1, failure to have a proper planning structure. A lot of people have the wrong structure. We'll talk about reasons that they may be wrong. But you want to have a competent planner. Make sure you have a good structure. Secondly, once you've got a good structure, it's still vitally important to review it periodically and adjust ownership and titling. Any client that comes to me after 2 or 3 years is going to have something that needs to change. It can be a very small adjustment, but sometimes it's very important to have this change. The next item is the failure to have appropriate beneficiary designations for life insurance, retirement accounts, IRAs, and annuities. It's a lot of darn paperwork. But if you make mistakes, then monies go to the wrong places, and you don't want that to happen. Number 4, failure to have enough life insurance. We're going to talk about that. You may need more life insurance now than you did in 2008. In 2008, we had more confidence on what an investment portfolio would earn, and you may have had a greater net worth. Is your family now protected with your life insurance? We're going to talk about that. Number 5, failure to focus on asset protection planning. You know, anytime you do something, you've got to look at it from 2 or 3 angles. And one angle is, how are the creditor situations going to apply to my estate plan? Number 6, we're going to talk about joint assets between spouses that should be protected if you do it right and aren't protected if you do it wrong. Number 7, we're going to talk about wage accounts, which have the same connotation. Number 8, we're going to talk about making sure you revisit the plan every 2 to 4 years. Number 9, we're going to concentrate on protecting spouses and the next generation. And number 10 is failure to do the estate tax planning. Now, on page 5, my slide says, make sure you have a proper system, a structure. And most clients that we have a structure like this. A revocable trust for each spouse, and on the first death, the amount that can pass estate tax-free goes into a trust that can benefit the spouse without being subject to estate tax at the spouse's level. Now, I really like this. We had a meeting Thursday with a physician client who really didn't see any insurance needs, but we talked about his wife, and she is not a physician. They own their assets jointly for the most part, If she dies, his creditor protection is not good anymore because he owns a lot of assets individually if she dies. So, and she's concerned that he might remarry and then have a new family and that her children would be out in the cold or the warm, depending on the month of the year. So we're putting a $3 million life insurance policy on her. It's going to be payable to her revocable trust, and on her death, he can be a co-trustee, he can get what he needs for health, education, and maintenance, but it's not going to be available to his next wife. So during the meeting, the financial planner said, we're going to get new wife insurance. We need new life insurance on the wife. And it was funny because she took that to mean that we were buying life insurance that was going to cover the next wife. And they don't have that anymore. I mean, they don't have that type of insurance yet, but give them time. All right, page 7, just more on the logistics. You know, you've got to just lay this out for the client. They usually don't understand it, but we do lay out charts, as most of you know, where the husband may have a revocable trust. That revocable trust doesn't provide any creditor protection whatsoever. It just is going to avoid probate, and it might have gotten him a free lunch if he went to one of those free lunch seminars. Other than that, the revocable trust simply turns into the other type of trust from page 6 on death. And then there's tenancy by the entirety's assets where creditors can't reach these. If you follow all the rules I'm going to talk about, then the wife may have a revocable trust. Then irrevocable trusts for the children have a lot of uses. And when I go to page 8, I show you that depending upon the value of assets, they may want to have subsidiary limited partnerships and LLCs in order to give them a better degree of creditor protection and the ability to do discount gifting. So that's all there on the table. Most of the people attending have already gone through this and understand it very well. So I'm going to go to page 9 now. Now, if you're interested in the estate tax law, let us know and we'll send you excerpts from our B&A book, Estate Tax Planning in 2011 and 2012. And we're looking at making this into an electronic book because I have a strong feeling that these laws are going to change in the next 3 to 5 months as they grapple with the budget situation to get our S&P rating back up. But if you're interested in the book, just give us a call. We'll be glad to at least loan you a copy or send you some excerpts. We've had a really good time writing it, and I don't think I'll ever write a book again. Okay, page 10, ideas for planners with respect to the new estate tax law. Go through this chart with your client or go through this chart on your own to the extent you can understand it and decide what you're going to do to take into account the new estate tax law. For a lot of clients, they don't want $5 million automatically going into a trust to benefit the spouse or to benefit the children. It used to be $1 million, then it went to $3.5 million, now it's up to $5 million. This may distort what the plan is, so the plan needs to be reviewed. And then there's other things you can do, like number 5, you can clean things up and simplify them. If you're pretty sure the client is never going to have an estate tax issue, it's time to really simplify things. They may not need these trusts and all these entities. We're doing a lot of trust mergers where you had 3 trusts and you merge them into one. And then there may be life insurance policies that people took out to pay the estate tax. And maybe it's time to look at those policies and cash them in or reduce the death benefits. So, and of course, making use of this new allowance for the wealthy clients to set aside $4 or $5 million into a trust that's never going to be subject to estate tax and could benefit the spouse. And if it's put in an asset protection trust jurisdiction, it can even benefit the client who sets it up. And we've been working on these, and they're, very nice. Now, it used to be a client would put $1 million, $2 million into this type of trust. Now it's $4 to $8 million for most clients in 2011 and 2012. So it's really time to spruce up the irrevocable trust forms, which we've been doing, and make sure everything's done properly. It's also a good time with this large allowance to go ahead and forgive notes to children, give them the house that they live in, but maybe ask them to get marital agreements for their children and test those relationships. Okay, number 2, failure to periodically review and adjust ownership. A big question is these joint accounts, are they tenancy by the entirety's account? If Marcia and I go in to open a joint account and the account agreement says that we can check a box for tenancy by the entireties or we can check a box for right of survivorship. If we check that box for right of survivorship, then that account is exposed 1/2 to my creditors, 1/2 to Marcia's creditors. So we really have to, even if the account says it's a TBE account on the title, you really have to look at the account agreement to make sure it's TBE. And if it turns out it's not TBE, you can't fix it retroactively. You just have to terminate that account and start a proper TBE account. And then, as I said before, living trusts don't provide asset protection. Sometimes they only get funded on death, and so clients get misled about that. Joint revocable trusts usually will not qualify as tenancy by the entireties. So those are big mistakes that get made. Now, as I said, beneficiary designations, those are a huge, huge issue for many families. For example, if I want to have my pension go to a protective trust for Marcia if I die, and I have put Marcia on the beneficiary designation and the trust is the alternate beneficiary, that works great. Then I die, Marcia has 9 months to decide whether to roll it into her own IRA or to let it go into the living trust.